Good morning, everybody. Well, good afternoon now. All right, just gonna give everybody a second to get in. All righty. Hi, everybody. Good afternoon and welcome. And thank you for joining us for our second presentation of our Spring Making Sense of Sense series. We will have one more presentation next week on Wednesday, and I hope you join us for that presentation as well. A good thing about attending all three of the presentations of this series is by doing that, you will receive a free consultation from a select group of elder law attorneys. So a nice little kickback for getting some extra education as well. Also, a friendly reminder to check out our website, alzbr.org, for all of our upcoming events. We have some really fun stuff coming up in the next few weeks. Also, you are welcome to call our helpline at any time, and we're happy to support you. That would be calling our helpline. I'm going to put our phone number within the chat box. That's a great way if you're having a challenge or have a specific question about a resource. We're happy to connect with you that way. Before I introduce our presenter today, I want to go over just our regular housekeeping spiel. All of the calls will remain muted throughout the call today. If you have any questions, you can type them out in the chat box, and I'll read them out during the question and answer portion for you. Also, our call will be recorded today and will be posted on our YouTube channel. I'll also put a link to our YouTube channel within the chat box just so you can save that. Okay, now I'm going to introduce to you our presenter today. She is Miss Myrna Arroyo. She graduated from Tulane University with an MBA JD in May of 1995. Before starting her own law practice, she practiced at several large law firms and has over 20 years of experience as a lawyer and entrepreneur. She currently focuses her law practice on helping families and business owners with estate planning, tax, and Medicaid planning. So no better person to help us dive into this topic and answer all of our frequently asked questions about estate planning. So welcome, Ms. Myrna. Thank you so much for taking the time to share all of your experience with us today and answer some of our questions. I'm going to pass it on over to you. Thank you for being here.
Thank you, Brooke. I'm happy to be here. So let's just jump right in. So today I'm kind of going to go over some of the most common mistakes that we see that people make with estate planning. And at the end of this presentation, it should give you just a really better idea of what you need, why you need it, and next steps to take to get some things in place for either you or a family member. So as you all know, these are like crazy times, right? We have a lot of unrest going on in the world and a lot of things going on here in the US that are causing some issues for some of our clients. So one thing, one statistic that's a little bit scary is that there's over 10 million civil lawsuits filed. I personally, as an attorney, do not do litigation, so I'm not part of these lawsuits, but it is something that really impacts a lot of people, a lot of our clients. America also has one of the highest divorce rates in the world, and it's been like that for some time. It's about 50%. And of key interest to a lot of our clients is nursing home and other long-term care expenses have really gone up a lot and continue to go up every year. Right now, the average nursing home or the median cost of a nursing home in Louisiana is about $6,500 a month, which works out to about $78,000 a year. So if your family hasn't planned for that, it can cause some stress as people get older. There are more than 53 million caregivers in America providing aid to family members or friends who are struggling with different issues of aging, like Alzheimer's or dementia. And because of poor estate planning, there's a lot of things that end up in court. So we see a lot of poorly drafted documents or just things that people printed off the internet that don't really work. And that causes a lot of litigation in families. So I won't spend a lot of time on this slide, just a little bit about me. I think you heard Brooke gave you a really good overview, but I have Progeny Law Firm. We're a small firm. There's 2 attorneys and 2 staff. And really, this is all we do is we help people with wills, trusts, and things to do with long-term care. So why do I do this? Why did I get into estate planning? So this is a picture of me when I was 10 years old with my grandfather. He passed away when I was 10. Our family is all from Puerto Rico. But when he died, he did not have any planning in place at all. So it caused a huge commotion in our family. He had 7 children total. He had been married before, so there were some that were from a prior marriage. And when he died without a plan, given like all his different little business interests and real estate and things he owned, it caused a huge fight between my mom and her siblings. To this day, my mother and her sister have just stopped speaking to each other. It got so bad. It was something that not only caused us to lose a lot of wealth that he had accumulated because it just ended up getting caught up in litigation, but it also really destroyed our family because there were people in my family, cousins that I never saw again after this happened. And it's just so sad, right? And so when I was growing up and going, when I went to college and I went to law school, my mother was dealing with all of these lawsuits, all of these things going on with the succession of my grandfather. And I just was always very curious about it. And that's why I ended up doing this. When I went to law school, I wanted to learn all about estates and trusts and wills and how to plan properly to avoid these things from happening in your family. And that's what I try to do for our clients today. Our firm, I originally started practicing on my own in 2002. Like Brooke mentioned, I had worked at some big firms before. Right now, we just have 2 attorneys. We really started growing a lot in this area in 2020. So after COVID, that's when I started hiring more attorneys. Before that, it was just me on my own. And we've really done a lot in the last 3 years. And part of what we like doing is helping out with organizations like this one to help get the message out about the importance of estate planning and getting your things together so that you don't leave your family with a mess. We're members of the American Academy of Estate Planning Attorneys, and it's a national network. They really help us out a lot. They help us with education and just keeping us up to date on things that are going on in the estate planning community at large. We are one of only 5 firms in the state of Louisiana. They're very specific about who gets allowed in. So it's something that I had to apply for and get accepted to. And it's just a great part of our network because even though we're a very small firm, we have all these resources backing us up. If you've never heard of the American Academy of Estate Planning Attorneys, it's highly recommended. So, they've been written up in Money Magazine. Susie Orman has mentioned us. Attorneys that belong to the Academy were required to maintain 36 hours of continuing education every year on estate planning topics. And because of that, and because of all the education that we have to do to stay in good standing with them, we are just, you end up being, with attorneys that are really going to take care of you. But anyway, that's enough about me. Now we're going to get into estate planning, what we're here to talk about. So first of all, by signing up for this, nobody wants to talk about what's going to happen when they die. A lot of people don't want to even think about, death or disability or incapacity. But by coming here and listening and just being open, you deserve congratulations just for doing that, because I know it can be a really hard topic. Death and taxes, nursing home expenses, family drama, like what happened in my family, the possibility that your plan may not work. These are all things that you have to face up to if you want to try to address them. And of course, if you are getting ready to think about this, you have some options, right? You can choose to do nothing. Just let the state of Louisiana kind of decide what happens to your stuff, when you die. And if you're incapacitated, you could just let the state of Louisiana decide who's going to be appointed to manage your affairs. You can have a will. So a will would be a very good way to plan for what happens after you're gone. You could decide to create a living trust, which is a different way to plan. Or you could do a comprehensive plan. It's what we call legacy wealth planning. It's where we kind of look at everything and take care of everything. And we're going to be talking about all of these options today. So what are the 7 mistakes that people make when they do their planning? So the first thing that we see is that they don't put a plan in place that's going to avoid the government telling you what to do with your things after you're gone. So whenever you don't have a plan, the state of Louisiana has a plan in the statutes that's created for you. And that plan will come into effect if you're incapacitated and you can no longer have capacity to deal with your own affairs. And someone has to be appointed as your curator. So in Louisiana, we call that an interdiction, but we also call it living probate, kind of as a nickname for that process. And then we have death probate, which is after someone dies, if there's no plan in place, or if there's only a will, you actually have to go to court to get all of these things taken care of and to file the will. The court was going to certify that will is valid. And then from there, you'll be able to distribute assets and follow the instructions in the will. So both of these involve a lot of court interference. You got to pay court costs. You got to file things publicly in the court record, which is why we don't really like that. So let's talk about interdiction. So the living probate, because it's like a probate, but you're still alive. So if someone's incapacitated in the state of Louisiana to the point where you just can't, you don't have enough understanding to make sound financial decisions for yourself or sound medical decisions for yourself. People always assume, oh, well, my wife will do it or my kids will do it. But if you haven't given them authority in a legal document that gives them permission to act on your behalf, most institutions won't just take their word for it. And what you could be forced to do, what your children or your spouse might be forced to do, is actually open an interdiction suit, file a suit in the public records that says, my wife or my husband can no longer manage their affairs. They lack mental capacity. I want to be appointed as their curator to take charge of everything. And that process, it's expensive, it's time consuming. It can take about 3 to 6 months to do an interdiction. It also tends to cost a lot of money because you have to have medical testimony, you have to get experts appointed, you have to appoint an attorney for the person that you're trying to interdict, who's independent, of course, of you. And all these fees can add up to, the court costs alone are usually about $2,000 to do these. And then you're also going to have to pay legal fees. So usually it costs between $5,000 and $10,000 to do a kind of garden variety interdiction. In the interdiction process, the court is going to hear testimony, they're going to review records, and they're going to try to figure out, A, is this person have capacity or not? And B, is the person that's trying to get appointed as their curator, should we go ahead and appoint them? Or is there somebody else that wants to be appointed? And then you can get into litigation, one side versus the other, who's going to get chosen. It's going to be up to the judge ultimately. As part of that whole lawsuit, they're going to have to disclose a list of your assets, a list of your liabilities. So all of this personal information is just going to be sitting in the court records, which are public. And again, you're going to have to pay all of these fees, like on the slide: court fees, attorney's fees, accounting fees, curator fees. So it can be a nightmare to go through. And then once you get it, right? So we have a client in our office who sadly had to do this for his spouse, and we were able to help him, but he worked offshore his whole life. And so she always managed all of their finances. So he didn't even know what accounts they even had, or he just wasn't on any of the accounts because he was never there. Well, when she becomes incapacitated, he has to somehow take over all of these financial things. And he didn't have authority. They had never done powers of attorney or anything. So we had to get him appointed as the curator for his wife. And then not only that, whenever it came time to sell their house, because they wanted to downsize to a smaller home that he could take care of easier, we had to go get court approval for every transaction. So once you're under the interdiction, you've been interdicted, that curator is still going to have to get court approval to spend your assets, to sell a home, to refinance a home, all of these things. So it just, it's just constant. It's not what you want. And then we can talk about shift from that to what happens after death. So after death, if there's not a really good plan in place, you end up having to file a succession or a probate. In Louisiana, we call it succession. In other states, they tend to call it probate. But generally, probate means that you're filing a will so that the court can establish that it's valid, right? So you're proving the validity of the will, and that's where the word probate comes from. This can also get expensive and time consuming depending on your family situation. When you file the will, there's always court costs involved. Here in Baton Rouge, it's usually about $500 or $600 to get it filed initially. Your total court costs on a probate is probably around $1,000, assuming it's a pretty simple one where we don't have to file a lot of different things. Depending on how your will is written, you may be able to do it quicker or slower. All of this is going to be up to the courts, right? You're going to file it, you're going to file your inventory, and then the court is going to say, okay, and then you can continue with the administration. Some of them drag out. Some of them we can get done really fast. If it's just like a house and a couple of bank accounts, we might be able to get that done in 2 to 3 months. But if it's a little more complicated, there's a business or there's assets you're trying to sell in order to distribute to different beneficiaries, it could easily drag on 6 months, a year, even longer. The one my mom was involved with my grandfather dragged on for decades because of all the disputes that were involved. So if everybody gets along and, everything is clear, it can be not as bad. Again, probate documents are public. So if you have a friend that passed away, you can go look them up in the courthouse and figure out what they had in their estate. It is possible to get that stuff sealed, but most people don't. Usually it's just public. Another issue that's interesting, those of you who own property in multiple states, maybe you inherited some land in another state or you have a vacation home somewhere. Every state has their own probate for their own land. So if you own land in Louisiana, Louisiana has jurisdiction, so you'll always have to have a probate in Louisiana. But if you die in Louisiana and you say you owned a piece of property in California, that California property is going to have to go through a probate in California, and then all of your Louisiana property will go through probate here. So as you can imagine, double probate, more costs, more fees, more delays. What does probate cost in Louisiana? It depends on the firm and how complicated it is, but typically a fairly simple one is going to be about $5,000, and they could cost as much as 30 or 40 depending on whether there's litigation or other things that come up as part of the process. You have to get appraisals. There's just a lot of costs that can add up. So these are all the reasons why, if there's a way to avoid probate, we should probably try to avoid it if we can. The other thing about probate that is annoying is that, so say, your parents pass away and there's a house and you and your siblings have decided that you really just need to sell it. Maybe everybody lives out of state. And say you find a buyer, a neighbor wants to buy it or a friend wants to buy it. Well, now, in order for you all to be able to sell that house, you have to finish the succession first. So you have to go open the succession, get somebody appointed, get the judge to sign off, get permission to sell the property. All of that has to happen. And so what it can cause is a lot of delays. So if you wait until you get an offer on the house to start the probate process, most likely that either that buyer is going to have to be really patient, or you might lose them because it might take 8 weeks to get an order signed by the judge that it's okay for you to list this house. So probate just injects delays and expenses. And so for that reason, if you have any kind of complicated, if you have a lot of assets, we always recommend that you try to avoid it. So planning mistake number 2, we talked about not having a plan at all, right? And you're stuck with interdiction and probate. The second planning mistake is not thinking about nursing home or long-term care. So if you're getting older, or you have parents that are getting older, it's really important to have a conversation about what their wishes are with respect to long-term care and what assets, what resources are there to pay for long-term care. So some people have insurance, some people have, if you have enough assets to pay for it out of your assets, that can be great. But if you don't have a lot of assets, and you want to try to protect the assets that you do have, then you need to think about including nursing home planning in your estate plan. So when we sit down to do your will or your trust or powers of attorney, we would also have a conversation about what are we going to do about nursing home. Like I mentioned earlier, the average nursing home is going to run you $75,000, $80,000 a year here in Louisiana. So if you don't have a lot of money saved up, that can go pretty quickly. Now, how do we pay for the nursing home? There's really 5 ways. So the first is to just use your own money. For some people, that works great because they've saved up, they have plenty of money, they can just pay for it, it's fine. But if you're in that situation where you have a little bit of money, but not quite enough for a long nursing home stay, that's when we have to really think about how are we going to handle this. So one option is to buy long-term care insurance. So some people have long-term care insurance through their workplace, or they bought it years ago when it was still pretty affordable. If you have long-term care insurance, that's great. The benefit of having insurance is, of course, usually it's pretty flexible. You can use it for home health or long-term or nursing home, or, someone to come in a few hours a week or someone full-time. It just gives you options. So if you are able to get long-term care insurance, that's a great thing to have. The downside of long-term care insurance, it's very expensive. So if you go out and get a quote, like in your 50s or 60s, you can usually still get a decent quote. But once you get past a certain age or you start to have some health issues, it's going to be hard to qualify that they'll even give you a policy. And then if you can get a policy, it's going to be pricey, maybe $300 a month, maybe more. So it doesn't work for everybody, but if that works for you, that's an option. Medicare, this is something that people get confused about, Medicare and Medicaid. So Medicare is healthcare for people over 65, and it doesn't really cover a long-term nursing home stay. What it covers is limited skilled nursing care. For example, if you have an injury or an illness and you need to be in a skilled nursing facility for a certain length of time, you can get coverage through Medicare for that short stay. But the intent of that care is to rehabilitate you and send you home. It's not for you to live in the nursing home for the rest of your life. So the coverage ends. Usually you get something like 20 days of full coverage, and then you get another like 100 days where you have to make a pretty big copay. But then once that's over, there's no more coverage. So at that point, you'd be forced to seek other ways to pay for the nursing home. And Medicaid is how probably over half of the people in nursing homes today in America are actually being paid for by Medicaid. Medicaid is a joint federal and state program. So even though it's a federal law and a federal program, the states have some discretion in how they interpret it. So if you're going to do Medicaid planning, it's really important that you find someone in the state where you live, because the rules are different in different states. Here in Louisiana, in order to be eligible for Medicaid long-term care, you have to be over 65. You have to need help with at least 2 activities of daily living, and you also have to meet certain asset and income tests. So for a single person, you can't have more than $2,000 in countable assets, and your income has to be less than the cost of the nursing home. If you're married, one of the spouses is in the nursing home. The non-institutionalized spouse, so the spouse that's still living at home, they're entitled to keep an allowance of about $154,000. So these are pretty low asset limits, right? So, I mean, think about $2,000 to your name. That's all you can have, as countable assets. And then some assets are countable, some assets are not countable. So for example, for most people, if you're living in your house and you're keeping it and you're going in the nursing home, as long as you tell Medicaid that you plan to eventually return to that house someday, they will let you keep that house. They won't count that against you towards that $2,000 limit. And they have rules about different kinds of assets you're allowed to keep. You're allowed to keep a car. You're allowed to buy a prepaid funeral up to $10,000. So when we're helping clients either qualify for Medicaid right away, if they're ready to go into the nursing home like now, we will look at, what assets they have. Can we take some of these things that are countable and turn them into non-countable? And we can kind of help plan to try to protect as much of their estate as possible. If we have clients that are able to plan ahead, we can protect way more. So this is where planning ahead can really help if you really want to keep, some of your assets to go to your kids. We have ways of creating special kinds of trusts and special planning techniques to try to protect those and still help you so that you can qualify for the Medicaid assistance for your nursing home. The last program I'll mention briefly is the Veterans Aid and Attendance Benefit. This is a really great program. It's kind of a pain to apply for. The application's difficult and time consuming, and you basically have to go to the VA and apply. Some attorneys will help you, but like our firm doesn't do that because you have to have this special training to do it. But the way the program works is you, if you were a veteran, and you qualify based on your military service, or your spouse was a veteran that qualified due to their military service, then you're able to apply for this benefit. And it usually is around $2,000 a month, and it can be used for home health, for assisted living, or for nursing homes. So it's very flexible. It's a really nice benefit. So we always encourage our clients, if they're veterans, to definitely apply for this. So those are the 5 ways that you can get that you can pay for long-term care. And that leads us to our next mistake, which is no divorce, creditor, or lawsuit protection for your beneficiaries. So one of the things our clients always talk about is they have their kids, right? And maybe their kids are adults now and they're married, and maybe they have a son-in-law that's not their favorite. Everybody has that. I know we call it the idiot son-in-law or the daughter-in-law that they don't like. We hear this a lot. So if you have one of these situations where you have one of these in-laws, a lot of times you want your assets to go to your child, but you don't necessarily want it to end up with the child's spouse if something happens to your child. So one of the things that we can definitely plan for is making sure that doesn't happen. If you have young children or grandchildren that you're leaving assets to, a lot of times people are worried that, they're young, they don't really know what they're doing, they might get taken advantage of. So there's some things we can do in your estate plan to make sure that doesn't happen. Kids, if they're young, they tend to get in trouble with money. Maybe they didn't file a tax return on time. Maybe they had a little car accident and got sued. So maybe they're just not financially mature. So if you have any of these situations in your family, there's certainly things we can do with your will or your trust to make sure that these do not happen, and that those heirs and beneficiaries are protected from all of these risks. So one of this is the divorce protection, right? So we want to make sure that if your child gets a divorce, that their ex-spouse doesn't end up with the inheritance. And granted, in Louisiana, we're a community property state, and generally when someone gets a divorce and, anything that was separate property stays with whoever it was. So an inheritance is considered separate property in Louisiana. So in on paper, those assets should be protected. But what typically will happen with inheritances with married couples is, say mom dies, leaves daughter $100,000 just outright. Daughter gets a check for $100,000, deposits her in her joint account with her husband. 2 years later, they get a divorce. Judge says, that account is all commingled with community and non-community property. We're just going to split it in half and give each kid half, right? The spouse and the kid and the ex-spouse. So the ex-spouse ends up getting half of that account because it got commingled. So there's ways to structure your will and put language in there that will make it to where that doesn't happen. The money that goes to your children will stay with your child and will not go to an ex-spouse. Another thing we can protect against is lawsuits and creditors. So if you have a child that inherits a bunch of money and the money's just sitting in their bank account and they get in a car accident, guess what? That money is considered available to pay any judgments, any creditors. If you leave the money in a trust, some other mechanism, we can actually make it to where it's asset protected. So no lawsuit can ever touch those funds and they'll be available for your child when they need it. Financial maturity. So I once read a very scary statistic in Forbes magazine. This was a couple of years ago, said that the average inheritance in the US is spent within 18 months. And just from the people that have come through our office, I definitely believe that this is true. So when you give people a lump sum of cash, for some people like these girls here, it's like burning a hole in their pocket, right? It's so easy to just spend it, spend it, spend it. But when you leave it to them in a special trust account, it just makes it a little harder for them to spend it as fast, and it makes them think about it. And so if you're trying to build a legacy for kids, grandkids, if you have that desire that, this money be used for the grandkids' college or anything like that, if that's one of your goals, then we can certainly help you make sure that we design a plan so that you can do that. Because otherwise, you're kind of leaving it up to chance a lot of times. We had a couple of guys come to our office. It was about 2 years ago now. Their parents both had sadly passed away during COVID, like very close to each other. And so the two sons ended up inheriting about $600,000 of life insurance, and it was 50-50. Well, one child was the responsible child. He was in college. He put all the money in his savings account. He paid tuition with it. And, he was being very careful with his money. The other child bought a Hellcat and then a Corvette. And by the time, 6 months after receiving this inheritance, it was almost all gone. And that's what can happen when you leave money to kids that just don't have the financial maturity to handle it. I mean, I know myself, if I had gotten a bunch of money at age 18, I doubt that I would still have any. I'm sure I would have spend it on all kinds of things. So doing estate planning and going through the process of having these conversations with an attorney while you're going through the planning process can help you make sure that you design it in such a way so that doesn't happen. Okay, so another big mistake is not putting remarriage protections into your plan. So if you think about typical married couple, husband and wife come into our office. This happens all the time. And we talk about, they basically say, tell me, I want everything to go to my wife. And then if she dies, then I want it to go to our kids. And then she'll say, yep, that sounds great. So this is what we call the I love you will. I love her. I want her to have everything. But if something happens to both of us, it should go to the kids. That all is great until we have the Cinderella situation, right? So what happened to Cinderella? Wife died, dad got remarried, and then dad died, and she ended up with evil stepmother who did not protect Cinderella's inheritance, right? So this happens every day. This is what causes, honestly, most probate litigation that we get calls about, and we don't handle litigation at this moment because we don't have an attorney in the office that can take litigated cases right now. But whenever we did take litigated cases, a lot of them came out of this scenario is couple, one of them died, the survivor ends up remarrying. Next thing you know, they're changing the will, and all these other people are now getting part of the inheritance that the original spouse that died never envisioned that this money would go to anybody other than his or her children. So this is something that's really important to talk about. And, some people don't care. Some people are like, whatever, it's her, she can do whatever she wants. If she gets remarried, fine, I don't care. But if you do care, if you do want to make sure that your children benefit from your half of the community property, then we can certainly put some things in your will or in your trust to address that. Because what we want to do is prevent, accidentally disinheriting your children, which we've seen that happen. They leave everything to the surviving spouse gets remarried. The new spouse maybe influences them to change the will, or they end up leaving everything to the new spouse. And then the son or daughter from the prior marriage ends up with zero. And, if that's a concern, that's certainly something that we can take care of through proper planning. Planning mistake number 5 is protecting your retirement accounts. So retirement accounts are a huge issue. They're great to have. So it's great if you have a big, nice big account in an IRA or 401k. You got a tax break when you put it in while you were working. And now you have, you've invested it wisely. And now you have this nice nest egg. The problem with these accounts is that, of course, now that you're retired or when you start to take the money out, you do have to pay tax on what you take out, which is normal. Everybody expects to do that. But when you leave those to your children after death, they now have to pay the tax. And so you have to be really careful with planning for these to make sure that we can pay the tax in the most advantageous way possible for your beneficiaries. So there's a lot of opportunities to minimize income tax if we do some proper planning with these IRAs. And we can also protect the IRA money, from a potential remarriage, all of these situations that we've been talking about, from the kids getting the money outright and just blowing it, all of that. So this is an area that, a lot of attorneys, so if you go to someone, all attorneys can do a will for you, right? You can go to any attorney and they're like, sure, I can do a will for you. I'll just do a little simple will. And a simple will is great, but a simple will is probably not going to address all of these mistakes that we're talking about right now. And that's why, I don't care if you come to me. I mean, I would love for you to come to me, but if you go to do an estate plan, definitely go talk to somebody that does this and that understands all of these little caveats and mistakes that can be made, because failing to plan for the retirement accounts can just cause, can just cause a lot of unnecessary taxes to be paid. Planning mistake number 6, this is my favorite, the fast food estate plan, right? So this is the do it yourself, or I don't have a lot of money, I have a simple estate, I just want the cheapest thing possible I can find. And there is a lot of stuff out there. We see it every day. I see ads for, on Facebook, like get a will, $50, whatever. And these are mostly software companies that are selling. Basically you pay for a subscription and you just fill something out and then they give you a will or a trust or whatever. And in and of themselves, it's not a bad thing. The problem is that you're getting the document, but you're not getting the advice that goes with it. And the advice is what you really need to pay for, because you want to make sure that what you're putting in the document is actually going to do what you think it's going to do in real life. So that's why these types of documents that you download off the internet often are a big problem. Other problems we've seen with these documents are they're not properly signed. So just had one in my office the other day, and it was actually done by an attorney, but the Louisiana has very specific laws about how you do wills. Wills have to meet all of the requirements. If you miss one of the requirements, the whole thing is null and void. So one of the things you have to do in Louisiana is you have to sign every single page of your will, and it has to be your full name. So I got one in my office the other day. Everything was fine, except it just had the man's initials on the first page. And guess what? Whole thing is null and void. So it's as if he didn't even do a will. So just a lot of things you have to be careful about. In Louisiana, you can still do a handwritten will. It's called an allographic will. And that's all great and good. I mean, it actually is a good thing. You know, if you're on your deathbed and you just don't have time to get to an attorney, you can actually write out your wishes and, you know, be able to do some planning. The problem is there too, is if you don't meet all of the requirements, again, the whole thing's going to get thrown out. We had one in our office, and this is a true story. The lady had done this handwritten will, and her daughters brought it to me for probate, and we started looking through it, and it was like 4 or 5 pages, and it was very detailed, and it was very well written. But when we got to the last page, she had signed it "Love, Mom," and because she didn't sign her full name, whole thing's invalid. Luckily, the 2 daughters were very, they decided to honor mom's wishes anyway. So it all worked out for mom in that case. But you know, you just have to be careful with these online wills. Now financial advisors are getting into the estate planning business. So I've heard of a few here in the Baton Rouge area that are starting to do this. And so, yeah, they send you to a website, you fill out a form, and then you're actually letting them do the estate plan for you. And again, there's just no legal advice that's really coming with that. It's just paper that you're buying. And is it really what you need? Some of the problems that can come up with these bare bones kind of things is there's not going to be if you especially if you use it to create a trust. You know, creating a trust is not just about signing the document. You also have to make sure the assets are titled properly. So if that doesn't happen, that's what we call funding, that process of titling your assets in the name of your trust. If that doesn't happen, the trust is useless. So that's one of the things that often when you go through a financial advisor company or one of these website companies, they're not going to help you with any of the details of making this thing work. They're just going to sell you a form. Often they're not gonna advise you on how to protect your assets from the nursing home. They're not gonna advise you about remarriage protection. They're not gonna advise you about asset protection for your beneficiaries. So you're just not gonna get the full service that you would get from an attorney. And then finally, mistake number 7 is not protecting your legacy, right? So when we meet with clients, we don't just want to hear about your money and your assets and how many houses you own. And I mean, we need to know that for sure. It's important. It's an important aspect of the estate planning process, is to get full financial information on all of our clients so that we know what types of assets are going to be in the state and how to best plan for them. But even more important than that is we need to know about your family dynamics. We need to know about your kids and your grandkids and your siblings and whoever is going to be involved in this plan after you're gone. We need to know, you know, does everybody get along? Are there, you know, is there some bad sibling rivalry that people have never gotten over that we need to address? You know, is somebody going to get mad if you give this to that one and not to the other one? So we want to kind of know the full story of your family and your values and what you're trying to accomplish, because that's a big part of planning too. It's not always just about the money. Because what we don't want is to create a plan that's going to end up in court, right? We don't want people to be mad at each other after there's a death in the family. We want this to be a time where they can come together, not be torn apart, which is, you know, what happened in my family. So to give you a summary of all the things that you don't want, right? So you don't want a plan that doesn't address, you know, what happens if I'm incapacitated? How do I avoid probate? How do I pay for the nursing home? If you want asset protection for your children, how do we do that? Are we worried about a remarriage down the road? Do we have retirement accounts that we need to protect? So all of these things have to be considered to make a good estate plan. You can't just it's not just a piece of paper. One of the ways that a lot of our clients, just to tell you a little bit about how we work. So when we talk to a client, when we meet with a client, we offer the initial consultation. And usually if you've been to one of our events, we do that complimentary. And then in that consultation, we're going to talk to you about all the things we talked about. We're going to talk about your family, your assets, your goals, what you really want to accomplish, because it's ultimately all about you. This process is all about you, not about what we want. It's about what you want. And as we're in that conversation, we're going to start coming up with, okay, we think this would be a good idea for you, but you also have this option. So we may say, in your scenario, based on the amount of assets you have, we think a trust is a good idea, but trusts are not for everybody. There's certain things that you have to do. And, so then we would say you could either do a trust or a will, and we would give you the choice. So why would we do a trust instead of a will? So the main reason we would choose a trust is usually if there's significant amount of assets. So if you have more than just if you have an estate that's a couple $100,000, if you have real estate, if you have multiple accounts with different investment providers, the more kinds and varieties of assets you have, the more likely that we are to recommend a trust for you. Also, the total size of the estate doesn't really matter. So we've had people with very small estates that decided on the trust instead of the will. And then we have people with really big estates that are like, you know what, I'll be dead, let my kids deal with it. I don't care. Just give me a will. So it's not just about how much money you have. It's more about how complicated your situation is. Do you own property in multiple states? Do you have a lot of different accounts? Do you have a lot of investments? We will consult with you on that. If you choose the trust, the benefit of the trust is that once you pass away, your heirs do not have to file anything in court. The entire document governs everything, and nothing has to get taken to a judge to get any kind of approval to do anything. It's all handled privately. So if privacy and ease are really important for you, then a trust is probably going to be more what you want than just a will. But again, that's something that we would have a very detailed conversation about your specific situation, your specific family, and then we would advise you both ways, and then you ultimately make the decision which way you want to go. But we just kind of guide you as to the consequences. Well, if you do a trust, here's what's going to happen. If you do a will, here's what's going to happen. And then what do you prefer? So it's ultimately going to be up to you. But typically how these trusts work is the trust is just a legal document. In that trust, we would write out, who do you want to be in charge of your affairs if you're incapacitated? Who do you want to be in charge after you and your husband are gone? If you're married, if you're not married, after you're gone, who is that person that's going to be in charge of everything? And then what do you want them to do with all of your assets? Who are they going to? Are there charities? Are there special gifts for nieces, nephews, whoever? How do you want to split the assets? Who gets what? We write all that out in the trust. The trust is usually a longer document than a will, but again, it never gets filed anywhere. Nobody ever knows about this trust except you until the day you pass away, right? Whoever you want to share it with. The one thing about the trust, though, is that you have to transfer all of your assets into the name of the trust when you create it. Otherwise, it's not going to work, right? Because the trust serves to transfer title from you to your beneficiaries. The will transfers title from you to your beneficiaries after death. Because it's after death, that will has to get filed in court, right? We have to prove it's correct. We have to go jump through a lot of hoops to make sure that we can do what the will says. With the trust, because you do all of the transfers while you're still alive, you're putting everything in the name of your trust. Then once you die, there's nothing that has to be done in terms of getting anything approved by a judge. People always ask me, if I put everything in the trust, am I going to lose control of it? No, because while you're alive, this trust is just for you. You're the only beneficiary. You're the only trustee. It's all still your money. You can still spend it. You can still do whatever you want with your assets. It's just that once you die, it's like a switch gets pulled willed, and now that successor trustee takes over, and then they take care of everything in your estate. So legacy wealth planning is kind of the way we plan for our clients. So like I mentioned earlier, we use this family trust usually as the centerpiece. Sometimes we use a will, but most of our clients are going to go for the trust. And then we have, we're going to include your financial considerations and also your non-financial. So your family dynamics, your values, goals, things like that. And we're going to put it all together into a really great plan. So knowing all this, what is the number one reason people do not do this? Procrastination, because we all love to procrastinate. The second reason people don't do anything is lack of knowledge. So if you don't know what you don't know, you may not realize how important it is to get this done. So I'm hoping that I kind of gave you a little inspiration to get this done. And really, I'm hoping that this gives you kind of an action plan. You know, you need to figure out, you know, go find somebody to talk to, get started with this, and get it going, because if you wait until there's an incapacity, it's too late. Then you're stuck filing an interdiction. And again, like I mentioned earlier, the most important part of your planning is what's important to you. So we're always going to ask you, what is your goal? What are you trying to accomplish? What do you envision for this legacy that you're going to leave to your family? So to just give you some next steps. So we, this is a shorter version of our seminar. Our normal seminar that we do is actually a little bit longer. We usually do it in person, and it's like an hour and a half. And we would love for you to come to one of those, because we will get into a lot more detail about all the things we talked about. And so if you want to attend, you can call Angela in our office, and that's our number, and she will get you signed up for one of our next events. If you'd like to just have a chat with myself or one of my other attorneys, you can also call that number and she'll get you set up. But we really love for people to come to our seminar, because you learn so much, and it's totally like no obligation. You just come, it's free, you listen, and then you can decide if you want to make a consultation and take the next step. So the last question I'll leave you to, and I leave a little time, just a few minutes for questions, is what legacy will you leave your family? So do you want to leave everything organized, planned, worked out, where they don't have a lot of stress? Or do you want to leave something that's kind of a mess? Because a lot of people, unfortunately, leave a mess, and then they have to hire attorneys to clean it up on the back end. And I'm a big believer in just planning right the first time, and then everything goes so much easier for your beneficiaries. So now I'll open it up for questions.
Thank you so much, Ms. Myrna. That was a lot of good information, and some information that I haven't heard before. So thank you so much for taking the time to in-depth explain a lot of those mistakes and questions that people probably have and may not have known previously. So thank you so much. If anybody has any questions, you can put those in the chat box and I'll read those out. I did want to mention one thing. Ms. Myrna had mentioned that veterans benefits, and how it does take a specialized knowledge of how to go around with the VA, what documents to file, what documents do you need. That is something that we actually have a resource list on, and I'm happy to provide that to you.
That's
We have
wonderful.
a whole resource list for legal in general. We list, different estate planners or financial advisors, elder law attorneys. And within that list, I also have a lot of good veterans resources. So I'll attach that in an email just to follow up with everybody after this. Good info. Okay, so on to the questions. Do you have any resources for families that cannot afford an attorney to do their estate planning?
So we typically send people to Capital Area Legal Services. If you truly can't, just don't have a lot of assets, and they'll do things like powers of attorney for you, the basic things, a very basic will. Yeah, so that's usually who we send people to that really don't have any resources.
Yes, thank you. And that's the legal resources that's a part of the Capital Area Agency on
I
Aging?
think so, yeah.
Yes,
No,
they have a legal team
it's
there.
Capital Area Legal Resource. So it's like it's from the Baton Rouge Bar Foundation, I think funds it. So it's just legal aid services. And they do events. I know the Baton Rouge Bar will do like a free will event, like maybe a couple times a year. So you kind of just have to, you can contact the Baton Rouge Bar or the Louisiana Bar and see what they'll direct you to who's doing those things pro bono. But there are opportunities to get it done.
That's great advice. Thank you. Thank
Yeah.
you for that. I have actually spoken with the office, the Louisiana Bar office, and they're very nice over there. So
Yeah, they're very
um,
nice. They're very
yeah,
nice.
yeah. Thank you for that. Another question is, how much trouble is it to transfer everything into a trust? Example of multiple investments accounts, some tax, some not, stocks, properties, etc.
So it's really not that big a deal. We do that. We do it for our clients. Like when we do your trust, we help you with all of that. So you're never like left on your own to fend for yourself. Um, Accounts are fairly easy to transfer. It's just filling out some paperwork. If you have a financial advisor, we'll usually work with them and between the two of us, we get it done fairly easily. Real estate, we do the deed to move it into the trust for you. The only thing that our clients really have to do themselves is if they have bank accounts, like at the local Hancock Bank, Whitney, whatever, wherever, you have to actually go in person. And so we give you some documents to bring to the branch, and then they can do the account for you. And that's really the only thing that requires you to personally go. That being said, it does take some time. It's usually like 30 to 60 days after we sign your trust before it's all done. And a lot of that is because, we have to send stuff off, wait for it to come back. Maybe they didn't like how we filled out the form. We have to help. We might have to redo some of it. But our paralegal takes charge, and we will make sure it gets done. Like, we help you.
Okay, good deal. Another question is it too late to set up a trust if your spouse has been diagnosed with dementia?
Um, It depends. We could certainly do it if they still have mental capacity where they can still kind of understand what a trust is and how it works, and they can talk to the attorney, and the attorney can feel like, okay, yeah, she knows what she's talking about, then yes, we can still do it. If they've lost capacity to the point where we can't do it, we can certainly do it for the one spouse's half of the estate, but with respect to the spouse that's incapacitated, we may not be able to fund everything. So it's something we'd have to talk to you, and it's kind of case by case, honestly.
So in that second example of that the spouse is incapacitated and not able to make those decisions anymore, what would you recommend for that family then?
Well, hopefully you have powers of attorney. So if you have powers of attorney, some powers of attorney will allow you to create a trust. So if you have one of those powers of attorney, then we could still do a trust. But if you don't have that, which sometimes people don't, then we really can't do any planning for the spouse that's already incapacitated. That's why it's important to try to do this. Like if you think that, someone is starting to have, the signs of dementia or whatever, get them into an attorney right away, because the longer you wait, the less likely is we'll be able to finish the process. Because it takes a little time, it's not like we can just do it instantly. It usually takes like about 4 or 5 weeks to get everything together. And so we don't want to wait till like the last minute.
Yeah, yeah. That was a question that I have. I have a few more questions. When would you recommend people start estate planning?
Oh my God. Everybody needs an estate plan. Now, depending on where you're at in life, it's less or more or not as urgent. For example, young families with young children, they need at least a will to name guardians for their kids, right? So we have all different kinds of planning, right? So when you're younger, it tends to be simpler. It's usually a will. It's not as complicated. As you get older and you have more assets, you start to get closer to needing nursing home care, then we start to get more complicated, right, in what you need. But everybody needs to have some kind of basic documents in place, powers of attorney, a will. I mean, even if you're 20 years old, you should have that. And it also costs less when you're young, which is fine because usually younger people don't have as much assets. But yeah, we help people at all stages of their life with this.
Okay. And then how often would you update the
Oh,
way
I'm
you
glad you
recommend?
asked that because I meant to say that and I forgot. But yes, we recommend with our clients, we bring them in for an update every 3 years. So we'll kind of review their plan and just make sure everything's still good, either on a phone call or a meeting. But for sure, every 5 years, like if it's been more than 5 years since you did your will or your powers of attorney, it's just good to get them revisited. Laws change all the time. And there may be new planning opportunities that weren't available when you did it the first time. Medicaid rules may have changed. There's so many things that change. Your own situation may have changed. You may have, maybe the person you named as power of attorney, you're like, maybe not. Maybe I want to name somebody else now. If you don't go back and revisit, you're going to be stuck with whatever's on there. And if you do become incapacitated, then you can't change anything. So, minimum every 5 years, you
Okay.
should at
And then I
least
know
look at it.
we're right at 1 o'clock. I'm going to ask one more question because I know this could be relevant to a couple of the caregivers that are on our call today. We do speak here with a lot of long distance caregivers. So either they themselves are out of state or their loved one that they're caring for is in another state. How would you recommend to somebody finding proper legal support in another state?
So I mean, the Academy of Estate Planners has attorneys all over the US, so that's a good resource. They, just to get referrals from somebody that is a specialist in this area. So that's a good source for a referral. But you can go find an attorney where you're at, and they may have somebody in another state. So we do that all the time. Because we do this, we know people in other states that do it, so we can always direct you to the right place. And most attorneys these days, they'll talk to you by Zoom. We can have a consult with, you're on Zoom, your parents are here, or you're here, your parents are on Zoom. Like, we can do all kinds of virtual things now to help. The only thing we're not allowed to do is practice across state lines. So we still have to work with an attorney in your area, in that area. So.
Well, good. Thank you so much, Miss Myrna. It's right at 1 o'clock, so we're going to go ahead and end today's presentation. But thank you so much for sharing your
Well,
time with us and your
thank you for
knowledge.
inviting me, and look forward to helping you guys with more of these in the future.
Absolutely. Thank you so much. Thank you to everybody that joined us today. Again, we have one more presentation within this series next Wednesday. Give us a call at our office if y'all have any questions. Thank y'all so much for joining us today.
All right. Bye.
Thank you. Y'all take care. Have a good one.
Bye.